at those things, and here's the objectives from the start of the chapter. So we're going to look in more detail about what type of things affect capacity and ways you can get out of contracts or attempt to get out of them. Yeah, and look at some things like misrepresentation, those things that affect your assent when you enter into a contract, and then some examples of when contracts have to be in writing to be enforceable. So we talked about capacity before. What were the two things that relate to capacity? Right? One has to do with your mental capacity to contract. The other had to do with whether you're the right party to contract, right? And I think most people understand full competence. That means you know what's going on around you and you understand the contract you're entering into. And I think most people understand no competence. They don't understand either one, right? It's the limited one that can create part of the issue. Perhaps you can function, but the question is, did you understand at the time what you were doing when you entered into the contract? That's the question. Not before, not after, but at the time. And what kind of things have we talked about that affect your competency to enter into a contract? Intoxication, right? That's one some people seem to be able to relate to.
Your age, if you're lucid enough to...
Right, maybe you are at a point, and that could take place at different ages, but with some older people, they get to a point where it's difficult for them to necessarily comprehend some of those things. So that might affect your competency. But we're going to go into some specific things that relate to your capacity to enter into a contract. We talked about minors a little bit. Notice some of the key words on this slide. If you were taking notes or highlighting the slides you already have, I would probably underline or highlight most. In most states, a person is no longer a minor for contractual purposes at the age of 18. What kind of law does that sound like it might be? State statutory law, right? Whatever the statute says, whatever the legislature has agreed, the age of majority is, then that's what it is for contractual purposes, and there might be different ages for other purposes. I may have mentioned already that I kind of disagree with the second bullet up here. It says a minor can enter into any contract an adult can. Well, it's trying to say that the fact you're a minor doesn't mean that you have diminished mental capacity, but there are some contracts that minors just can't enter into because it'd be illegal for them to do that. Like what?
Tobacco and alcohol.
Right? Smoking, drinking, those type of things. Buying alcohol for others. Those things would all be considered illegal contracts. No contract. Yes?
Since you say you kind of disagree with it, would you...
I do disagree. I wouldn't even say kind of. I do.
Would you put a test question on? Do you want us to follow the book or follow you?
I just gave you an answer to one of the test questions. How about that?
Can you repeat it?
Sure. C. C. Now you just have to figure out which test question that is. Now I was talking about where I disagree, and I gave the example of alcohol, and I said that you can't contract to purchase alcohol for yourself as a minor, and you can't contract on behalf of anyone else because you lack the capacity legally to do that. So what kind of contract would that be? No. What? Illegal, void. No contract, right? So you just can't do it. Then notice the one below it. Then it says a contract entered into by minor is voidable at the option of that minor. So if the contract is a valid contract entered into by minor, it's voidable. Remember that from last time? That's not supposed to be a trick. Voidable contracts are valid contracts that one of the parties could back out. In this case, only one of the parties, only the minor. It says at the option of the minor. The adult can't go, oh, you're a minor, I back out. They're stuck with it. All right, disaffirmance is a fancy legal term that we give to that minor exercising their right to avoid the contract. Disaffirmance is backing out. I don't want to be in this anymore. Now, for me, it helps to have kind of a timeline up here. Let's say a minor contracts, and then at some point in the future, they reach the age of 18, the age of majority in whatever state. According to that first bullet, when can the minor back out? No, not any time. Before they contract? No, that wouldn't make sense.
It just says a reasonable period after the minor comes of age.
Okay, so help me out here. From when the contract started, when? Tell me when to stop.
That's when.
Right here?
That's reasonable. I mean, you don't want, they can't wait.
Oh, but this is
They-
before. This is before.
No, it says a reasonable period after the minor.
Oh, okay, so keep going. Here I go. Yeah, sound effects are good for the recording. Tell me when to stop.
Right there.
Right here? That's a reasonable time? I don't know. It's not up to us. It's up to the court, right? So, according to that first bullet, from the time of contracting until a reasonable time after reaching the age of majority. All of that time. And the court has to figure out what that means, right? I mean, it's pretty easy for us to figure out between the time of contract and 18. They can get out at the age of 18. Still, it's this reasonable time afterwards. The court's got to figure out what that reasonable period of time is. If they do decide to disaffirm, then they have to disaffirm the whole thing. They can't say, "I'd like to keep the car. It's just the payments. I don't want that part." And that disaffirmance can be expressed or implied. How could they imply during this time period that they don't want to be in the contract?
Don't pay it.
Right. They don't. They act like they don't want to be in the contract. They don't pay. They bring it back and don't say anything. So those would be considered implication. Or they could say, "I don't want this anymore. I'm not going to pay for this anymore." Now, why in the world, because some people would say, like, well, minors should be responsible. Why do we have laws like this that say a minor can do something and then change their mind and get out of it?
Minors do things impulsively?
Yeah.
Yeah, they do, right? So what do we need to do? We need to protect them. Minors are impulsive. Later on the slides, we'll learn they're liars. We'll learn they have poor judgment. I mean, this is generalizations, right? But we need to protect them because they'll make decisions to buy big-ticket items because they're pressured into it or just because they want it, and they should be able later, when their parents bring them to their senses, realize that they don't want to be in it. So, as we go through these, you don't just think, "Wow, this seems unfair. Minors get anything they want." Also think, well, minors aren't old enough, and so they should be protected until they're old enough. So one of the questions is, well, okay, they can back out, but do they have any obligations when they do that? In most states, I would underline most, the minor only needs to bring back the goods that they have. So if they don't have it anymore, oh well. If they have it, but it's diminished in value, it's beat up, it's torn up, that's what they bring back. Again, doesn't sound entirely fair.
They don't have to pay a depreciated value or anything?
Well, look at the next one. It says, in an increasing number of states, the minor must restore the adult to possession home before the contract was made. It means you drive a car off a lot, it depreciates. You're a minor, you drive it around, you're going to tear it up. You bring it back, it's not worth near as what it was when you brought it off the lot. Some states are starting to say you can't just buy a car, trash it, and then bring it back if you have it. They're saying you can bring it back, but if you do, then you ought to, pay the difference if you wreck it or depreciate it or whatever. But again, notice, first bullet, in most states still say, well, don't contract with them in the first place if you don't want them bringing back a piece of junk. I'm paraphrasing the statute a little bit, but now you been in the class long enough, you know, I get you to understand it, and then I say there's a bunch of exceptions. Right? It's just the way the law works. Sometimes, though, the reason parties contract with minors is because they believe they weren't minors. Because a minor told them they weren't a minor. Right? I mean, again, minors make impulsive decisions. They also lie about their age. To get into places, to buy things. But, notice the first generally. Hear that word generally? Alarm should go off in your head. Generally, minors are known to lie about their age, so you shouldn't really believe them. You should do something objectively, commonsensically, that's a word, to verify how old they are. You don't just look at them and go, okay, if you say so. You check them out, make sure they are old enough to sell whatever.
If they're a minor, they're going to have a fake ID.
Of course. So there's got to be some point. I mean, I guess the question is, what's this misrepresentation look like? Is it negligence in your failure to check because you just trusted them? Or is this like, I went through all the steps I could to verify their age and they falsified documents and had a fake ID which was contrary to state statute and that type of stuff. So it really comes down to what the statute says. But in a growing number of states, the statutes are starting to change to say, now if you go as far as lying about your age, then you ought to be stuck with whatever you lie about. So again, general rule, minors get to get away with it. Some states are coming down a little harder. Now, minors can back out of contracts unless the contract is for necessaries. So if what the minor is contracting for is something that's necessary for their living, like food, clothing, shelter, then they ought to have responsibility for those things. Why? Going back to what we said about why we have these statutes, this protects them. If we didn't have this, then whenever somebody was asked to sell food, clothing, or shelter to a minor, they'd be like, I don't think so, they're not going to pay me for it. Now notice what it says. If you really read the bullet, it says, contracts for necessaries may be disaffirmed by a minor, who then remains liable for the reasonable value of the goods and services. So they could say, take it back, but if they do to necessities, then the law says somebody's going to pay here the reasonable value of whatever that good or service is, which usually translates to mom and dad, but got that? Now I'll give you exceptions. Here's a couple. Generally, most courts say that insurance is not a necessary. Now, I've had a student argument with me before, well, it's necessary to have insurance if you drive. That's true, but what did your parents say about driving? Maybe they just said it to me. I've heard all kinds of ones that advice people got from their parents. Mine said it's a privilege, not a right. And so therefore, you could, if you get the privilege of driving, yes, you need insurance, but you don't have to drive. Although some people would argue, well, I have to drive. Make them walk, I say.
What about
But
in
doesn't
the
the
state
law
of
say
Michigan, you have to have a minimum liability insurance.
Well, the law says you have to have it, but you don't have to drive. There's not a law compelling people to drive. Oh, I guess I probably could prove it wrong. But as far as I know, there's no law that says, like, no minor comes to the parents and goes, there's a law, I gotta drive. Right? Some of them have tried it, but I don't think the parents fell for it. All right. Loans. Loans are not necessaries. A minor going to the bank or whatever and asking for a bunch of cash, like saying, I need money to survive. No. Unless the loan is for what? Necessities, necessaries. So if a person could establish that they weren't giving the food, clothing, or shelter directly, but they were giving money for those specific purposes, then they should have to pay for that. Ratification is the opposite of disaffirmance. So ratify means expressing a desire to remain in the contract, because remember, it's a voidable contract. It's your option, get in or get out. Back to our timeline. Minor contracts for goods. This is when he reaches or she reaches the age of 18. According to that slide up there, when can a minor ratify a contract?
At 18.
Can't. It's a trick. They're not a minor at 18. So I kind of disagree with this bullet too. Right? It says occurs when a minor on or after reaching maturity. Well, that doesn't even make sense. So what that says is this. They can't ratify here. They can only ratify here. Right? Since they're so impulsive and confused and lying, you don't want to trust them to ratify or agree to stay in a contract while they're a minor. You only want to let them do that after they've reached the age of majority, but only for a reasonable period of time. Did that make sense?
No, say that again.
Which part?
They can only ratify after 18, but they're not a minor.
Right. They can
During that
technically,
period of time.
if a minor contracts, they can get out of it during this period, but they can only agree to stay in it during this limited period from age 18 and for a reasonable period of time afterward. And they're not a minor, right? Minors don't ratify because you don't trust them. They could change their mind again. They're flip-floppy. Again, I'm making generalizations. I mean, I know adult people who have issues with this. So, and they could do that expressly or impliedly. How could you imply, once you reach the age of 18, that you want to stay in a contract? Yeah, you act like you're in it. You keep making payments, you keep taking the benefit of the contract, and you never let the other party know, I don't want to be in this anymore. Right? On me, on my 18th birthday, as I blew out the candles, I said, I hereby ratify all contracts I entered into as a minor. I blew out the candle, and that was it. That was my express ratification. You probably didn't do that. Probably weren't even really aware of that. Anybody enter into a contract as a minor? A what?
At 18.
At 18? Okay, so you weren't a minor. For contractual purposes. For other purposes, maybe you weren't of sufficient age to do it. Cell phone contracts? I remember I had a bag phone. But anyway. So, yeah, some people do. Most often, though, if you contract as a minor, who else is on there?
Parents.
Right, somebody who's not. Often parents. You know, if you love me, you'll co-sign. If you love me, you'll let me have this contract or this whatever. Which all of this relates to executive versus executory contracts. So far we've been talking about just contracts and whether we can stay in them or get out of them. Think about what we said in our group activity last week about executory contracts. So they could be continuing during minority into adulthood, and the question is, as they continue, could we decide to get out of them or stay in? Sure. We were just saying that. If we got installment payments we're making, what do? We either stop or we keep making the payments. If we keep making the payments on an executory contract, that's implied that we want to stay in the contract. Now, this is one that comes up, so I understand why the author put it in here. I don't understand why the author goes into so much detail about torts, because we talked about torts already. We're talking about contracts, but anyway. Generally, if minors run around by themselves contracting, adults aren't automatically a party to those contracts and shouldn't be liable for them. Doesn't that make sense? I mean, if it were the case that adults were stuck with every contract a minor enter into, then people would just get minors to do it so they could bind adults to the contract. So if you want to get a parent bound to a contract, you do that by getting them to be a party to the contract. Or we were mentioning co-signing as an example. Torts are a little different. Minors are certainly responsible for their own torts. If they go out and punch somebody out, they're responsible. If there's a statute that makes parents liable, they might be. I mean, one argument is I don't have control over my kid all day. They're at school doing whatever. But I was taking my son around Dick's Sporting Goods the other day, and all over the gun cabinets there were signs that said that parents or adults could have liability for leaving unsecure firearms around. Which makes sense. I mean, if your kid does something negligent with a weapon that you gave them or you gave them access to and you didn't properly secure it, maybe you should have liability for that. Not that we should have a long discussion about that, but I just leave weapons laying around and then watch my kids to see what they do. Don't do that. All right. I think that's enough about parents' liability. So one of the things that we said affects capacity is whether somebody is intoxicated enough. And we already mentioned that what we care about is what was their capacity at the time they were contracting. If they didn't have the capacity, then it's a voidable contract. Now notice up there it says either voidable or valid. Remember, voidable contracts are valid contracts. What we're saying is either it's valid and they're stuck with it, or it's valid and voidable and they can get out of it. And remember, the court looks at the objective conduct of the parties, not what they say at the time. Well, I don't remember what I did or whatever, but they look at, did the parties act as if they knew what they were doing. If it's voidable, if they can establish they lack capacity due to intoxication, then they can either stay in or get out. Now, notice we've added a couple terms in the last few slides here. Stay in means what? At the bottom there, what is it called when you stay in? Ratify. Stay out or get out means disaffirm. Good. So that's not a term just confined to minors. When I was talking up here about disaffirmance and ratification, I'm talking about the act of getting in or staying out or getting out of a contract. Questions about that? Yeah.
How does an adult, because a minor, it says, I guess my question is, how does an adult disaffirm a contract?
Well, an adult disaffirms a contract when they're intoxicated or later, and they're able to establish that as a result of that intoxication, they lack capacity at the time they formed that contract. And so the court gives them the option. Stay in, that means ratify. Now, they could ratify it by doing what? Just acting as if they're in a contract. And then later they're like, oh, I was drunk at the time. Well, if you were, then why didn't you, as soon as you discovered you're in a contract you didn't want to be in, do something about it? So I'm just saying, like, these are different claims related to capacity. Could you be both? Could you be a drunk minor? Yes. Right? Shouldn't be, but you could be, I guess. All right, now mentally incompetent persons and the 3 V's. Void, voidable, and valid. I think we've talked about this a little bit already, but I'll do us a timeline again here. Same timelines, same contract, but at the time of the contract, there's a question as to whether somebody had the capacity to understand what they were doing in the contract because of some mental issue related to competency. So, the first question you want to know is what? Based on what you see up there, what is something you would want to know?
Have they ever been declared incompetent?
Right. So, the real issue you're getting to is what is their competency at the time, but one of the first questions you might have is, what's the court's opinion about this? So let's start with that one. Before a person contracts for something, let's say I have been doing really weird things, and my family says we're going to establish a guardianship over me, and they go into court and they get a declaration that says I am not competent to contract for myself, and they're now my guardian. Then later, on this date, I walk into a car dealership naked and claimed to be the king of Naked Land. And I offer to buy all the cars on the lot because I have a lot of money. In Naked Land. I was going to say something about bucks or something, but I so I would say objectively, somebody looking at me probably would think this guy's got issues. But what capacity do I have to enter into contract? None. If I did, it would be what? Of the 3 V's up there? Void. It doesn't matter. Let's say I'm clothed, I'm just one-on-one car, and I seem fine. Doesn't matter. Still a void contract. Which seems unfair to the seller, but them's the breaks. That's what you need to do to protect people who've been declared to be incompetent, because they will do stuff like that. All right, so let's remove that and say it's over here after the contract. So, because I keep walking into dealerships and doing what I did, my family says, problem, and they get a guardianship established over me. Well, we already have answered the question, what happens after that? I can't contract, right? But the question here now is, what about the contracts I entered into leading up to my court appearance?
It depends.
The answer is it depends. It depends on what my competency was at the time. So in order for the guardian to avoid that contract, the guardian has to establish that at the time I contracted, I didn't know what I was doing in the contract. And if they can, then what kind of contract is it? Voidable. Now, let's say there's been no declaration by any court, before or after. Now, what's the only question? Let's say I lack competency, but there's been no declaration by any court. But at this time,
Now they have to determine if
right.
you were competent
What was
at
my...
the time.
Yes. So let's say that I have lucid intervals. Notice the bottom one there? Like at the time I enter in that contract, I'm fine. This happens. Medication, whatever it is, it could happen. The person's fine. If that's what's established, then that's a valid contract. But if they weren't, if they didn't understand, if they lacked the capacity, it would be a voidable contract. Not void. You only get that if prior to the court determines that you lack capacity. So you guys could, if you had a scenario, you could figure that out. Not picking it up in the recording, but they're all giving me a big thumbs up. Awesome. All right, legality. We mentioned before when we were talking about the elements of a contract to have me killed would be illegal, so don't do it. But there are other ones, right? A contract to do something that the law prohibits is not a contract to start with. There are other ways you could have a contract that's contrary to statute. Usury, as an example. Anybody know what usury is?
Charging interest.
Right, charging too high of an interest rate that's in excess of the legal interest rate. So if there's a statute that says you can't charge that high of an interest rate, then you can't enter into contract to charge that high of an interest rate. That would be an illegal contract. It would be void. Another example is gambling. You can go to a properly licensed casino. That's okay. You can gamble with the government through the lottery system. That's okay. I actually, by some odd coincidence, had the director of the Michigan Lottery in my office today. I should have asked him about it. Who is also an attorney, by the way. Should have him come in and talk to you about it. But if it's outside of those things, office pools, bingo that's not properly licensed, I gamble, I play poker with my kids all the time. Those are illegal. Any attempt to collect on that, the court could not enforce, because if they did, it would be to enforce an illegal agreement. Now, licensing statutes are a little different. And here's the rule. If the licensing statute is designed to protect the public, then you need the license to do it. And if you don't, it's not a contract. So I have to be licensed to practice law. If you guys left here saying, oh, I went to business law today, I'm a lawyer, right? And you're like, I'll represent you in court or whatever. You can't do that. That's against the law. There's a law that says you can't practice law without a license, and any attempt to contract to do that would not be a valid contract. It'd be a void contract. There are other licensing statutes which really aren't about protecting the public, but they're more just to generate revenue for the state. If that's the case, then sometimes the court lets those stand and lets the other party collect. For example, let's say there's a law that says cab drivers have to have a license. Well, do cab drivers get any special training or something to protect the public? Not from my experience with them. Right? It just generates revenue, regulates the industry. So you shouldn't be able to find a cab where the person isn't licensed and then not pay them. That's what this idea is. Now, there are other situations where if you contract with somebody who's licensed, or unlicensed, you might be able to collect, but they can't. In Michigan, in order to do remodeling, you have to be a licensed residential alteration contractor. If you're not, and you contract with somebody, they can sue you for doing a bad job, but they don't have to pay you. So you do the work, and they don't pay you. You sue. The first thing you have to put on the complaint in your lawsuit is your license number. You're like, don't have that. Well, too bad then. Can't help you. So maybe that doesn't seem entirely fair, but that's to force people to get a license to do those type of things. It protects the public. All right. Contracts and restraint of trade. This one isn't necessarily as obvious as a contract to kill someone. This is more of there's an agreement that the parties have, and the effect of it is something that's contrary to public policy. It's bad to restrain trade. It's better to allow competition. Well, where that might translate for you is, has anybody ever had an agreement with their employer that they're not to work with a competitor, and maybe that continues even after they're employed? Yeah. So one of the issues that's come up with those agreements is, are they an unreasonable restraint of trade that will not be enforced in court, or will the court say, look, you guys agreed to it, good enough for us? Yeah.
Is that kind of what happened with the Bratz dolls?
I don't know. I don't like those dolls. They send a bad message. Be a brat. That's cool. Sorry. What were you saying?
The creator of the Bratz doll was sued by Mattel.
Oh, okay.
Because he was working for Mattel.
Oh, okay.
He created the doll, and he took it somewhere else.
Oh, well, it could be a number of things. everything from trade secret to he agreed while he was working there that he wouldn't be in competition or even afterwards. There was a big one. I don't know if I mentioned this. There was a big one, I think, between HP and Oracle right now. HP fired somebody, and then, I think the CEO, and Oracle picked up the CEO, and now I'm sure I think HP has already started a lawsuit saying he couldn't be over there working without having some kind of trade secrets or violating some agreement we had against working for a competitor. So yeah, those things happen. Somebody in my last class mentioned hairdressing, which actually think about it is a pretty common example. Like, you do hair one place, you develop a client list, and then if you jump ship and start one across the street, that would be in competition. So in these agreements, the court usually comes down and says, how long and how far? How long is it that you have to wait before you could do something that would be considered a competitive? And how far do you have to be away from them to do it? So in the last class, a person said 5 years within a 10-mile radius. Well, I guess, I don't know. I don't know enough about hairdressing, obviously, but I don't know. 5 years seems like a long time to me, but...
When I worked for HP, I decided...
I thought you were going to say when I was a hairdresser. When you worked for HP. Oh, that's right, you worked for HP.
When I worked for HP, I signed a contract that says I couldn't go and work for any other computer company for a year after, and I couldn't work for a company that I was contracted to for, I think, 5 years, because I was actually there and I knew people and I'd be able to get into different things, so and I'd be able to take apart the computers and do whatever I want with them. So
this concerns me a little bit. I see the way you look at my laptops. Yeah. So I mean that's a good example of saying not only don't we want you to come in competition with us, but we don't want you to use our trade secrets, customer list, whatever, to even go to a subcontractor or somebody we have a relationship with.
Years ago, I worked at Honey Baked Ham as a full-time employee.
Ham. Sorry.
And our contract was we could not divulge the secret
Yes.
for 2 years after employment. During employment,
Isn't it kind of obvious, honey?
Actually, no.
Oh, now you can tell us?
Yeah, it's been more than 12 years.
Yeah.
It's pioneer sugar and cinnamon.
Pioneer sugar and cinnamon. Oh. Sounds good.
I heard that KFC is the same.
Yeah.
You know what? I worked at KFC for 5 years. Why do you people need to be like that? Why don't you believe me? I started in high school, and I worked through community college at KFC. What?
I said you didn't go to CC either.
No, I went to KCC. But I worked at the Kentucky Fried Chicken in Hastings. And my mother was my manager. And she fired me. She fired me. She fired me for, she asked me to do something, and I said no. And she said, you're fired. I said, you can't fire me, you're my mother. She says, I'm your boss. That was the only time I tried to collect unemployment. I was mad. Back then they had unemployment offices, and I went right to the unemployment office. Like, you guys still think I'm making this up? So I go to the unemployment office, and I'm like, this is what happened. And I said, and she fired me, and I'm like crying. Right? Well, you can't collect unemployment. I'm like, why? Because she told you to do something as your manager, and you refused to do it. You're not getting a dime. So I still won't go over to her house.
That's why we don't believe you. Keep going with stories. Just keep going.
I could verify these things. I could call my mother right now. In fact, one of the associate dean's secretaries used to work with me at KFC. She was a manager there at the same time. I will walk by, she's like, aren't you? I'm like, yeah. I used to work with you at KFC. Ask me any question about KFC, I'll tell you.
What's the secret recipe?
I can't tell you that because which was my original point. Which is my original point. They don't tell you. They hide it from you. They just give you stuff. You mix it together. See? Did you work there? See, you could verify if I know or not. What are the mashed potatoes made out of? Powder and water. Fakes, just bzzz, and there you go. That's it. I mean,
coleslaw comes in bags.
oh yeah. How do they make the gravy? They just take drippings and crust and stuff and throw. Well, maybe that was just me. Maybe I made it differently. I don't know. But it was so long ago. I was actually a waiter, a cook, and person that worked out front of the cash register. Like at the KFC, they had waiters. I had a bag phone too. So. Okay. All right. So, unconscionable contracts. I can verify all these stories. Like one day somebody said, and I caught myself on fire. And somebody's like, no, you didn't. I'm like, oh, yeah, I did. And I went to the what do you call it? Those urgent care things. And I walked in the door with this bowl. And when I walked in, they're smiling. I'm like, oh, what? And they start laughing. I'm like, what? And they said, what'd you do? And I said, I burned my face. I caught myself on fire. They're laughing. They're like, you win. They were betting on why I was carrying this bowl in. Because they said everybody who comes through the door of urgent care with a bowl either burned themselves or is sick. So, and I'm like, my class is like, you did not catch yourself on fire and run around on fire. So I called somebody and verified it. I mean, I can do this if I can back up the things that I say.
It's just the after stories that come after.
What? Like, and I haven't been to her house since.
Yeah.
Like your mom.
Okay, that part isn't true. I love you, Mom. You're right, I can't stop. All right, unconscionable contracts. Unconscionable means to shock the conscience of the court. It might look like a contract, but it's so unfair or one-sided that the court won't enforce it. So most of the time, the court just says, too bad, so sad, you signed it. But sometimes the court says, whoa, when you did, this was a problem. So there's two types of unconscionability, procedural and substantive. So on the left, procedural unconscionability means the circumstances that you entered into the contract are suspect. Like notice the factors that are listed down there. Is the print inconspicuous? Is the language unintelligible? Did one party lack an opportunity to ask questions? What was the bargaining power? So think about it. If you were selling somebody a product for a whole lot of money and you were concerned they might later claim that it was unfair, what might you do in the contract to address some of those factors? Right, list them all out. Big, conspicuous font, numbered, clear language, and at the end, say what? Yep. Any questions? Initial here. I've read all the above terms. I agree with them. Sign. So that's the procedural part. The other part is the substantive part that, maybe somebody can't establish the print was too small or the language too complicated, but it's so unfair or overly harsh to one side, the court just won't enforce it. So the example I've used in the past is, little old lady has to pay 3 times the value for the refrigerator. The case goes to court, and the court says, look, you've paid for it twice over. Keep it. You don't have to pay the rest. Now, usually when I say that, somebody jumps in with, what about rent to own? Or what about, I thought the court didn't get involved in that type of stuff. Usually they don't. But they can get to if they can just say, oh, substantive unconscionability. I like to say that. All right, exculpatory. So, to exculpate means to avoid liability. Have you ever seen this when you go to enter into an agreement or you're someplace where you're buying something, you see a sign that says, we're not responsible for things that happen to your stuff, or, what about you go through a car wash, right? You pay for a car wash, they provide you with a service. The sign says, if your antenna gets knocked off, your mirrors, whatever, your problem, not ours. Those are attempts to exculpate. Now, if it like chews up your car, right? You're driving through and your car all of a sudden gets tangled up and destroyed in the car wash. That's probably not something that they could avoid liability for. I had a buddy that this happened to. He had a Jeep different than mine. And he took it to one of these fancy car washes where they... What? This happened to you?
Mm-hmm.
Really? What happened?
I had the time, I think I had my Denali. I was going through one of these car washes, and it, you put it in neutral.
Yeah.
It somehow it wouldn't catch my tires. I
Mm-hmm.
don't know, and it kept throwing me through the thing, and it didn't get dented up or damaged, but it just kind of rolled through the whole thing. Stuff was kind of, things slammed, my mirrors like slammed.
Mm-hmm.
It was just kind of like, at the end he says, you know what, just don't come back. Something, it can't, something like, you don't have to
Just
worry, I
don't come
won't.
back, yeah.
Something like that happened to my mom too.
She was walking through? I mean,
She was driving.
oh, okay, so it was her car.
Her antenna got ripped off and it got slammed up against the side of the car.
Oh, yeah.
All dented and
And did they say, too bad, you should have put it down?
Sorry.
Yeah. Well, this example I was going to use was more extreme. This is a car wash where they take your car through for you while you sip coffee and watch it. And then when they get done, they buff it out, and then they ask for a big tip. So he gives the valet his Jeep, and he sits down and he starts sipping his coffee. And just before the Jeep goes to go through, all of a sudden it accelerates, smashes into some concrete barriers, goes into the parking lot next door and smashes into some cars. So he gets up. He's in total shock. He runs out to see what's going on. And he said the worst part of it was that a few of the employees ran over and started buffing out the Jeep, like, oh, maybe he won't notice. And so he said even worse than that was as he's talking to them about, what they're going to do, they said, we should have really fired him. And he's like, what are you talking about? He said, well, the reason the concrete barriers are there is because the same guy launched a vehicle into the parking lot last month. So did you know what he was doing? He'd panicked and he crammed the accelerator instead of hitting the brake and launched the Jeep. But there's a sign there that says we're not responsible for damage. It's like, this is not going to cover it.
I think they should be responsible for that.
Yeah, definitely. Yeah, definitely.
What if it, is that in any condition at all? Like with those signs, if you drive up to a car wash and it's not, everything's working properly and your mirror gets ripped off, okay, I can see maybe, they're not responsible. What if, the equipment malfunctions and falls on top of your car?
Right, that's why I think that you can attempt to, my point is you can attempt to exculpate yourself from that, but usually the courts aren't going to go along with that. Like if the car wash blows up while you're inside of it, that would not be covered, I would think. Yeah.
Would an example be if you went to a ski resort or something and you got yourself hurt, you knew you had to go at your own risk, and you're well aware of that, but you try to sue the place that you went to?
Right. So there was this actual case where this guy goes on he rents the skis and he goes on a double black diamond, and when he gets on it, he freaks out. So there's ice on it, goes off the path and gets injured. And so he sues, and it turns out in the discovery phase that one of the workers admits that the bindings were cracked, and they rented him the skis. So then now the ski resort's arguing double black diamond, your own dumb fault, you panicked, you assumed the risk. Well, his attorneys are arguing, well, yeah, but you don't assume that risk. And then the whole case was about when that defect occurred. Did they know about it? Did it occur from the manufacturer? And somehow it was in the logs that it was cracked.
So then why did they give them to them?
This is what they were asking. If you can say, rent our skis and we're not liable if you go out there and injure yourself, and they better be working. I mean, do you assume the risk that you're going to be rented defective equipment? That's the question. Yeah.
So basically, is it
Oh, I'm sorry, just one more point. the question was whether he wrecked the bindings or through his own negligence, accident, or whether they did. And it came out in discovery that they knew about it before he did that. Sorry, go ahead.
So if you sign one of these waivers,
Right.
so you don't have any recourse?
No, that's not what I'm saying. I'm saying you can attempt to, you know, as somebody who's contracting, you know there's risks that you're going to get sued for about everything. So some of those risks you can say, look, here's the risk, you assume it, I'm not going to be liable. I want to exculpate myself from liability. If you want to go down a double black diamond and kill yourself, that you know that could happen, that's your choice. So you could exculpate yourself from that liability. I'm trying to think of something risky I did lately, and I had to sign some agreement. Right.
An incident. We
Oh,
went
okay.
to the Caribbean last year, and I wanted to zip line. The couple that was with us was a larger couple.
Yes. Did they go in front of you or behind you?
Behind us.
Oh.
Because the husband had to be double harnessed.
Uh-huh. This is a sign.
Well, when you come off the line, the guy is there to catch you.
Right.
Well, he did. The man came off the line and they couldn't stop him, and the guy went off the tree. We were only about 2 feet in the air.
Okay.
But the guy went off, and the guy hurt his ankle. So
Yeah. Right. Yeah, I mean, again, you know, we talked about in torts, there's assumption of the risk and the argument, oh, well, yeah, maybe our equipment hurt you, but you assumed the risk that could happen based on your weight. I mean, a lot of those exculpatory clauses try to address things like that. I mean, this activity is not for people who are out of shape or whatever the condition is, right? So, anyway, onward. Now, I just got through telling you that if you contract to do something illegal, it's not a contract. Now I'm going to modify that a little bit by some of the things that are on this slide. Sometimes you're in a contract, you've been acting like there's a contract, they've been acting like there's a contract, but something comes up and it's questionably, there's a question as to its legality. For example, what if you have been paying on a contract that has a usurious interest rate? Usury in excess of the legal interest rate.
But if you didn't know that there was a law prohibiting
Right. That's what I'm saying. You're in, like the refrigerator example I used. Like the reason you paid 3 times the value of the refrigerator is because all along you've been charged whatever percent interest. And there's a law that says on this type of consumer purchase you can't be charged that high of an interest rate. Well, you go to court. Now, if the court just says there isn't a contract to start with, where does that leave you? With no refrigerator, right? And having made payments. So sometimes the court might allow you to withdraw from an agreement that's illegal because you don't want to keep paying the illegal interest rate. Sometimes the court might sever the legal part from the illegal part. You get to keep the fridge, you have to pay the legal interest rate, you don't have to pay that in excess of. So, in fact, the court might say, according to our calculations, that the legal interest rate, you've already paid for it. So these are all examples of, well, I know we said illegal is no contract, but maybe if later we might do something else with it. So notice several or divisible contracts. Maybe it's like an installment contract. So something becomes illegal, we can not worry about that part and keep the part that's lawful.
So if you take something like that to court, and
Yes.
they find that you've already paid 2 or 3 times the amount for it, would you, like, what in some cases, I mean, I know it depends, but would it be possible to then get like a judgment, like for damages for that? Like,
What you've paid in excess? Usually not. Usually the court will say, well, you entered into the agreement, so it would be unfair to not get whatever it is that you bargained for, but we're not going to give you back the difference. I don't know. You probably could find a case where I'd be proven wrong in that, but more often the cases are around the court either saying there isn't a contract or there is, but you don't have to pay anymore. You should have caught it sooner.
Right.
All right. Now we're going to talk about things that relate to that genuineness of assent, or in this case, voluntary consent. And remember bilateral and unilateral? Bi meant what? To. In the case of bilateral mistake, to what? No.
Both parties agree.
No. Both parties two mistakes. Both parties are mistaken. So both parties are mistaken about the same thing. And that thing is a what? A material fact. Right? So maybe it's the subject matter of the contract, or it's something that's really important to the contract. But both parties, buyer, seller, whoever, both have a mistaken belief about a material fact in the contract. There was a case in your chapter about that. Maybe that's coming up on another slide. What page is that Chevy emblem there on? 247. So in that case, there was a question about whether a provision related to excessive mileage was a mistake by both the parties. Or maybe it was something else. Let's say I contract to buy a car part, and I believe it to be a car part for a 1947 whatever. And whoever's selling it to me believes the same thing. Now, when we go to exchange the part and the money, we both realize it's not. Wouldn't it be unfair to make us both stick to that agreement? They can't produce the part because they don't have it. They can't find it because it's 1947. And not that it's 1947 now. The part is from 1947. And I don't want it. It would be unfair to make me take it because it's not what we believed it to be. So if both of us are mistaken, the general rule is that we can back out, either one of us. In a case of unilateral mistake, only one of the parties is mistaken. And the general rule there is if only one of the parties is mistaken, too bad for them. So if I buy a car and I pay too much for it, I can't go back and say, oops, you know what? I think I paid too much for this. I want my money back. Just say, oh well. So general rule, only one party is mistaken. They shouldn't have made the mistake. Unless, now the exceptions. Unless at the time the one party made the mistake, the other party knew they were making it. Like I think, oh wow, I'm going to buy that rare coin. And the other time, the other party's like, hee, I know that it's not really.
Like,
Or hee. Or the second bullet up there, a mistake was due to substantial mathematical error or made inadvertently without gross negligence. So, you and I agree to buy my Jeep for $10,000. I mistakenly typed 1,000. I left a zero off of the end. Now it comes time for me to deliver, you to pay. You give me a check for 1,000, and you grin. It could be a couple things, right? You knew I was making a mistake, so you're trying to take advantage of it. Or you didn't know, but I shouldn't be bound to a typo. Typos are different than just a mistake on my part to estimate what something's worth. Let's say my builder says he'll build a barn for me for a certain price, but then the price for materials goes way up. He's like, oops, I made a mistake. Oh well. And that's what this kind of goes into what I was just saying in terms of if you make a unilateral mistake as to quality or value of a product, then that's your own fault. Usually you're stuck with it unless one of those two things, either the other party knew you were making the mistake or it's just a clerical error. Maybe that help you kind of map out. If it's a bilateral mistake, it's on the next slide. And there's that case. Both parties are mistaken, and either one of them could back out. All right, fraudulent misrepresentation. Fraudulent misrepresentation occurs when somebody intentionally lies about a material fact in the contract. Material fact is underlined. That means not just an opinion. And that misrepresentation could be by something somebody does or says or doesn't do or doesn't say. Like they had an obligation to disclose something but don't disclose it. So if I represent that this car has a certain number of miles on it when I know it doesn't, that would be an intentional misrepresentation. And sometimes, whether something was an intentional misrepresentation comes down to a question for a judge or jury to decide. Like even that last case, the Chevy case, the dealership case, in that case the appellate court ended up sending it back to the lower court because they needed a factual determination of something. And basically it was the dealer being dishonest, or were they really just both genuinely mistaken about something? I actually had that happen to me too. Now I can't say anything without you guys thinking I'm making it up. But I was digging through my papers last night because I was looking for a paint color for my wife. And I came across a letter from GMAC that said they were going to sue me for not paying the excessive mileage on a lease. And what had happened is I went into, when I was done with my lease, I was over on miles, and I went into a dealership, and the dealership said, don't worry about it, we'll take care of the miles if you buy this vehicle. Well, and they put that all in writing and everything, but apparently never informed GMAC. GMAC gets the return on the lease back from any number of places, and they got it back, and they didn't have a check for the difference, and threatened to sue me. So, in that case, the question is, are they not honoring their agreements and intentionally trying to collect money they're not entitled to, or are they mistaken about that, or is it a bilateral mistake?
Since GM's car was in your name from them, can they legally sue you?
Well, this
And
one,
then you have to go after
yeah, this car was in their name. They were just getting it back, and when they got it back, it had more mileage on it than I agreed to put on it. And I was supposed to pay, but part of the reason I did the deal on the next vehicle was they said they wouldn't charge me for that excessive mileage. All right. So in order to have fraudulent misrepresentation, you need these three things. You have to show intent. It's not an innocent misrepresentation. You could possibly say something that turns out not to be true, but you didn't know it was untrue. The other party has to justifiably rely on it. Whenever you see those two words together, there's two parts to it. Was there reliance, and was that reliance justifiable? You guys remember that? Larry off building his structure in the backyard for his RV. And then the last one, plaintiff must have suffered a legal injury. So what are you out when you buy a car that has much more mileage on it than you thought it did? Value, right? I mean, you're getting a car that's got a lot higher mileage than you thought. So you need those three things, and there's room in each one of those for it to be a problem. Like say somebody lies to you, but then you take it to a mechanic or something, and they discover it, and you're like, well, I know it's got problems, but it's a good deal. I'm going to do it anyway. Well, then you didn't really rely on the lie. All right, undue influence and duress. Make sure that you understand each one of these and what the difference is between the two. Undue influence is more about the relationship of the parties. So, parties in the special trust relationship where one party takes advantage of that. Attorney-client, guardian-ward, CPA-client. Those situations where one party's trusted for their expertise or advice in an area, and that other party uses that to have the party do something they shouldn't really do. Usually it's about power and emotion and being able to influence somebody psychologically. Versus duress, which is all about threatening or forcing somebody to do something. You don't have to be in a special relationship to hold a gun to somebody's head and say, sign here. That would be considered duress. Is it possible you have both? You could say, oh, come on, sign this. And then when they say no, you threaten to shoot them. But they're different things. It could be a threat of physical force. It could be actual physical force, beating somebody up to make them sign a contract, or extorting them, having information and forcing them to enter into an agreement. Notice the last bullet there. It is not enough to say you need to buy this car by 5 p.m. before we close or no deal. And then later you're like, they told me I had to buy by 5. I just did it. Now, sometimes there are statutes that have cooling off periods, like if you do buy something that you might statutorily be able to back out of it, but not on an argument that it's duress, that you were forced economically to do it. All right, and then statute of frauds. There's some slides after this that go into a lot more detail. This is a good slide, I think, because it lays out the different types of contracts that need to be in writing to be enforceable. I think most people can understand this contract for the sale of goods priced at $500. Just look at the price. Get a scenario. If you see a scenario and it says $400, that should make you think, Now, just because you see a scenario that says $400 doesn't mean there's not another reason it should be in writing. Notice the second one, contracts involving an interest in land. It doesn't say a contract to purchase real property. It says any contract involving an interest in land. So land contracts, contracts to purchase land, leases, all those things should be in writing to be enforceable. The next one, contracts that cannot be performed within 1 year. Let's say I contract with somebody to dig a hole. It's my house. So I contracted, let's say, to have somebody dig a hole on October 7th, 2011. According to that rule up there, does this contract have to be in writing to be enforceable? They're all answering yes. Okay. What if it said buy?
No.
Why not? Right, because it says contracts that cannot be performed within a year. When could this be performed?
Anytime.
Anytime. Today, tomorrow. Right? So only if there's a contract to dig a hole on a date that's more than a year in the future. Now, why in the world would I contract for somebody to dig a hole next year?
There could be property sitting there that has to be torn down.
Right. Things that need to be cleared first before I put in the hole. What happens if I say buy and now there's a hole sitting there? What happens to my hole?
It's all filled in.
Right. Right. It could be filled in with water. It could be filled in. Some kid can run by and fall into it. It could collapse. Right. All kinds of things. Animals live in there. I don't know. So that would be bad. So I could say there's even a more basic reason I don't want this hole dug until this date. This actually happened to me. That's when I was going to start pouring money into it. That's true. But I didn't want it until a certain date because I didn't own the property before that date. Doesn't that make sense? You don't want to dig a hole and start pouring money into it until you own the hole. Like, who owns the hole before you do? Doesn't someone else? So,
Plus, it's not a hole.
What?
Unless it's not.
But if it is, like, well, I mean, this is what happened. Builders will often buy up lots in subdivisions, and they'll put their sign out, and they'll say, "We'll sell you the lot if you let us build the house." Right? Sell you the lot, and whatever that costs, plus the price of the house. And so my builder, I didn't like look for the builder. I looked for the lot. I found the lot. I'm like, we want that lot. And I looked up who the builder was. Then I ran around and looked at what the builder had done, and I'm like, okay, I'll do it. Well, then I contract to get the foundation dug out, and it's a ranch. And the day before they're supposed to start digging, they get a call from my construction loan lender who says, "Don't dig." And then so the next day I'm out there waiting for my hole, right? Nothing. What's going on? Your lender called us, told us not to dig. So I called up my lender. I'm like, why do I not see any diggy? Right? And they said, well, because we don't want you to dig until we close. And like in our subdivision, everybody did it. Everybody started and was digging and putting things up before all of this. Right? So, I mean, they had a point. Basically, the point is, if it didn't close, if it didn't go through, now my builder has a lot with a hole and concrete in it. And it's mine, but it's on property I don't own. I guess I don't really own the hole. I only own what's in the hole. He owns the stuff around the hole. I mean, I guess I own the hole, but what am I going to do with the hole? Right? It's just air. I don't know. Like, give me my foundation back. You can keep my hole. So that was really weird. Contracts containing collateral promises. Well, who talks like that? Who says contract to fulfill an obligation someone else has? No one talks like that. What is that? Collateral promises to answer for debt of another. You guys read it, right? You all read it? What is it talking about there? What does it sound like?
If you have to do something or do something.
No.
You have to have something of value.
No. Yes, cosigner. Right. Exactly. So collateral promises to answer for debt another means you, not the party to the contract, agree to pay if someone else doesn't pay. Or agree to pay whether they pay or not. Now, why would you do that? Why would you, not a party to the contract, put yourself on the line to pay when someone else can't pay? Because you love them, right? Dumb reason. You want them out of your house, maybe. So, the rule is, if you're going to be a cosigner, it needs to be in writing. Doesn't that make sense? Like if you weren't in the writing and someone came looking for you, they're like, so-and-so's not paying, we want you to pay. You'd say, for what? And they'd show you the contract. Your name's not on it anywhere, right? Well, that's a contract between you and them. Sue them. So if you're going to be on the line to answer for someone else's debt, it should be on a line and you should sign. Make sense? All right, now that it makes sense, throw at you the main purpose rule. What page is the main purpose rule on?
What's the main purpose?
Yeah, that's what I'm trying to figure out. Can't you just tell us? You read it, didn't you? As you were reading it, didn't you say, you know what? I'm going to make a note of this. I need to ask him a question about this. This I just don't understand. 257? Yes. Yes. Say that. Read that aloud. I want to get it on the recording. Use your recording voice.
An oral promise to answer for the debt of another is covered by the statute of frauds unless the guarantor's purpose is accepting secondary liability or in accepting secondary liability is to secure a personal benefit.
See, talking and recording's harder than it seems like, isn't it? Did you guys all understand that?
No.
I didn't either. I was hoping somebody else got it. Yeah. Basically what it's saying is you can't orally promise to answer for someone else's debt. It needs to be in writing unless the reason you're orally promising to answer for someone else's debt is because it benefits you. Let me give you an example, because I'm seeing some, like what? Right, yes, that would be an example. The reason you're co-signing it so you can get the benefit of the car. I had this happen the other day. My son came to me. He said, "Can I have $10,000?" I'm like, "What do you need $10,000 for?" He's like, "Video games." Video games? You haven't paid me the last 10 grand I loaned you. He's only 10, but you know, he really likes his video games. And so he said, "Dad, I have an idea. I'll go to the bank and I'll borrow the money and then I'll give it to you to pay off what I owe you." That sounds good. So he goes to the bank. Guess what the bank says to him? "You need a cosigner. We're not giving you. You're 10 years old. We're not giving you $10,000. You probably spend it on video games." So he comes to me and he's like, "Dad, I need a cosigner." So I go in there and I'm like, "Hey, Betty, good to see you today. You know me. If he doesn't pay, I'm good for it." I say this orally. Well, why am I saying this? Because I'm about to get $10,000. Right? Not because I really want to assure them that if he doesn't pay, I will, because I want them to give him the money so he'll give it to me. And so if that happens, then it doesn't have to be in writing to be enforceable. Now that didn't really happen. You know, most everything I tell you happened, but that one didn't. You know, what bank's going to lend a 10-year-old money?
That
one right?
More realistic than the other.
Really? Like that one you almost believe. Right. I thought for sure your son was borrowing 10 grand for video games. All right. Well, that's what most of the rest of these slides say. I'm not going to go through each one of them. It talks about the right. Well, okay, now I am.
I mean, oh man.
Bummer. So I'm just going to go through it real fast. There's one that's not on that slide, but it is on here. Promises made in consideration of marriage. Well, like prenuptials are an example of this. Like, if the reason you're doing it is because you're going into marriage, then that's something you probably need to go see your own attorney about and put in writing. So that later, if the issue comes up, it's like, here's the writing, here's where the parties were independently advised. And so the law says that type of agreement, prenups, those should be in writing to be enforceable. All right. Here's the only difference on this slide. Notice when it talks about exceptions, it mentions how under the UCC, you could have an oral contract if the goods are customized. I mean, the whole idea of the statute of frauds is you need a writing because without it you can't prove there's a contract. But if somebody made custom goods for you, there's a good chance you must have had some kind of agreement, because why would they do it? At least that's the reasoning of the UCC. And then the last one, if they're sophisticated merchants who are free to enter into pretty much any agreement they want, one thing they could do is orally agree to do things. All right, now we're getting near the end here. I said you had to have a writing, but the law says the writing doesn't have to be much. Write it on pretty much anything you want. It could be a check, it could be a memo, a letter, an email. Anything that's a writing is good enough. What you need is a signature from the party who you want to enforce it against. So I orally call you, say I want to buy something. You email me, fax me, send me a letter with your signature on it. That's all I need to enforce it against you. I don't need my own signature agreeing to it. I need your signature. So a check with a memo, some indication on the memo line would be enough under the statute of frauds. And all it has to really